Hey, so this is all about the independent executor in Louisiana. So Paul Rabley here, estate planning lawyer. I want to talk a little bit about what the independent executor is all about. So whenever somebody dies, they own assets in their name, house, real estate, bank accounts, investments. There's going to be a succession to get that stuff transferred to the heirs. So in 2001, our legislature approved somewhat of a simpler procedure. Still got to go through a succession, but it can be a little bit simpler if you meet all the requirements of an independent administration. So if someone is not an independent executor, then every action that executor takes must be approved by a judge before the executor takes the action. Executor wants to pay a light bill on the house that the deceased person owned, got to get a judge to approve it. An executor wants to sell the old clunker of a vehicle that the person who died owned. Judge has got to sign off on that before the executor sells it. Executor wants to sell the home that the deceased person owned, got to go through a bunch of red tape, got to advertise in the newspaper twice, about 6 weeks apart, got to get a judge to approve the sale. A lot of delay, a lot of bureaucratic red tape. Now, if the executor is what's called an independent executor, then that independent executor can take those actions that would have otherwise required a judge to approve it, and the independent executor can do it without needing a judge to approve it first. So a lot simpler if you have an independent executor, or if there was no will, an independent administrator instead of just an administrator. So how does somebody become an independent executor under a will or an independent administrator? Well, as far as the independent executor goes, the will can authorize it. So the will might say, I name my son John Smith as the executor, and my executor may act as an independent executor. So that enables, the executor to act as an independent executor. If the will was written before 2001, it's not going to say anything about independent executor because our laws didn't exist then. So if the will doesn't say anything about it, then all of the heirs who inherit under the will can sign off on the paperwork to allow the executor to be independent. So that's how that works. If there's no will, then those heirs who are going to inherit under the state law can all agree to allow an administrator to be an independent administrator. So if you're involved in a succession and the executor is not independent, or the administrator is not an independent administrator, somebody's probably not cooperating, and you're probably going to go through a lot of difficulty, because I've never seen a succession where it didn't make things easier when the person was an independent executor. So you always want to go through that independent executor. The independent stuff doesn't eliminate the need for the succession or probate. Still got to do all the inventory, sworn descriptive list of the assets, got to do the accountings, judge has to order the transfer of the assets, still got to go through all that stuff. There's just less, red tape that the people who are involved have to go through. So that's the deal. If you're going to go through a succession, if there's going to be an executor, you're going to want to make sure that executor can be an independent executor. If you're a participant in a succession where the person who died had no will, probably going to want to allow whoever that administrator might be to be an independent administrator. It just simplifies the process. However, sometimes people don't cooperate, and you got to go under the old method, and it's really difficult, and it's a pain. So there you have it, independent administration in Louisiana. Make sure you have it. Make sure you're aware of it. Know what your rights are. Go Tigers.